From Charlottesville, Mr. Toscano.
Thank you, Mr. Speaker. I rise for a point of personal privilege.
So may proceed.
Thank you, Mr. Speaker. Mr. Speaker, ladies and gentlemen of the House, I think the Attorney General has it right. I would like to point out a few things about how he came to this decision. First of all, I think that he is respecting the legal system by doing what he's doing. When he took his oath of office, he took it to uphold the Constitution of the United States. It's not an oath that should be taken lightly, and he is not taking it lightly. If you see his release, he said after considerable deliberation and consideration of the law, he came to the conclusion that this law was not something that he could enforce. Secondly, there is precedent for this kind of action being taken by Attorney General in Virginia history. Just last year, Attorney General Ken Cuccinelli took the position that he would not defend the Opportunity Educational Institution on constitutional grounds. He's the Attorney General of the Commonwealth of Virginia. We had passed a law. He had concluded it was unconstitutional and therefore would not defend it. At the same time, you might remember several years ago, former Attorney General Jerry Kilgore joined with 43 other states' Attorney General in 2003 to argue that an Attorney General is properly carrying out his constitutional duties when he seeks to invalidate a state law that he believes in his independent judgment is unconstitutional. Well, why did the Attorney General come to this conclusion? Well, the Attorney General has concluded that our law against same-sex marriage violates the due process and equal protection provisions of the 14th Amendment to the U.S. Constitution. There is precedent in Virginia law on this point as well. It finds its form in the infamous case, or the famous case, of Loving versus Virginia. In Loving versus Virginia, you might recall it had to do with interracial marriage. And the Supreme Court in that case stated, and I quote, "The freedom to marry has long been recognized as one of the vital personal rights essential to the pursuit of happiness." In other words, marriage was a liberty interest, and Virginia, the Commonwealth of Virginia at the time, was violating that liberty interest and the Equal Protection Clause of the 14th Amendment because the freedom to marry or not marry was being based on racial characteristics. We have the same situation going on right now in Virginia. The law says that you cannot marry if you are gay, but you can marry if you are straight. That is a violation of the Equal Protection Clause and the Due Process Clause of the 14th Amendment. The Attorney General has concluded that Virginia should no longer be able to discriminate based on those you love. He has it correct. History will show that he has it correct, and I applaud the Attorney General for the action that he's taken. Thank you, Mr. Speaker.